I'm Kevin Dent QC, and I'm lead counsel in the Turkey Human Rights Accountability Project. And we are pursuing an application to the UK government for gross abuses of human rights in Turkey to be placed on the UK global sanctions list. My co-counsel, who we'll hear from afterwards, is Michael Polak, and he will talk about some of the particular cases that we are pursuing. But can I start by saying it's wonderful for us this afternoon to hear from some of the real founders and leaders in this new area of law who are an inspiration for our campaign, and to hear the invaluable advice today about how to pursue these applications, and also to learn about how our application can be advanced in combination with others. We are preparing a written application to the UK Foreign and Commonwealth Office and hope to be able to submit it in the next few weeks, or at least the first tranche of our application. Why are we bringing an application? Well, as Dr. Kerim underlines, the problems for human rights in Turkey have now come to a very serious stage. There is a combination of a culture and legal framework of impunity for ill treatment of human rights defenders that makes Turkey a seriously dangerous place, it seems, to be practicing as a lawyer these days, particularly one defending unpopular causes. And it seems that impunity is to a considerable extent now enshrined in Turkish law. So that's the difficulties. And the reports about the repression, serious human rights abuses, and lack of effective investigation of those abuses are legion, and they've been reported on many times. And the comments from Dr. Kerim this afternoon only highlight the problems. So there is a very serious problem at the moment in Turkey with human rights, and particularly in relation to lawyers, rights defenders, and other civil society activists who appear very largely to be taking the brunt of the repression. One high-profile example of this from recent years that I witnessed at close hand is the trial of civil society activist Osman Kavala and 15 others on absurd charges that they had plotted back in 2013 conspiring together with international powers, of course, to overthrow the Turkish state by organizing a protest against plans to redevelop the Gezi Park in Istanbul. The 16 were all charged on a really Kafkaesque 600-page indictment that disclosed no evidence of any criminality. The European Court of Human Rights, as Dr. Kerim has indicated, ruled that Osman Kavala, who'd been in detention by then for 2 years, should be immediately released from detention. This was ignored by the domestic courts, and he remains in detention. And I was in Istanbul in February 2020 as a trial monitor on behalf of the United Kingdom Bar Human Rights Committee when Osman Kavala and the other defendants were acquitted following trial. And there was very brief jubilation on that day until later on that day, President Erdogan publicly denounced the verdicts, and Osman Kavala was promptly rearrested at the prison gates on equally absurd charges. And it's now clear that he's likely to be detained for a very long time. And the usual checks and balances that would protect his rights are not there, or simply no longer effective. But we're very conscious in our campaign that figures like Mr. Kavala are powerful and prominent members of society. The situation for those less influential and powerful is far worse. And Michael will, in a few minutes, tell us about some of the cases that we're pursuing. The situation for lawyers, in particularly in Turkey, seems very, very grave, and there seems little, if any, recognition of the role that lawyers play in defending rights. And it seems as though if you are a lawyer defending unpopular causes, be it Kurdish groups, leftists, or others, then the state makes little distinction between you and your client, with catastrophic consequences. And so our campaign has a particular focus on lawyers and those who are defending human rights. At the framework for our application in UK law, the starting point is the 2018 Sanctions and Anti-Money Laundering Act, which largely, in many ways, mirrors the US legislation, in which persons deemed to be involved in serious rights abuses can be placed on the United Kingdom sanctions list. That was the legal framework, and that was then detailed and clarified in regulations from 2020. And those regulations are now in force, and persons involved in serious human rights abuses can be placed on the UK sanctions list if they have been involved in an activity, this is the definition, amounting to a serious violation of an individual's right to life, right not to be subject to torture or cruel, inhumane or degrading treatment or punishment. So it's quite a wide ambit. Person can be placed on the list if they are involved in such activity. And again, the ambit of what's meant by involved is quite wide. A person is involved if they are responsible for such activity, if they facilitate or incite such activity, if they conceal evidence of such activity, if they provide financial services that will assist such activity, or if they profit financially from them. But in particular, and this is something key to our own campaign, if the person is responsible for the investigation or prosecution of such an activity and intentionally or recklessly fails to fulfill that responsibility. And we are bringing a legal campaign, and we are presenting detailed written submissions to the Foreign and Commonwealth Office. Some would say that an application to place persons within Turkey on a sanctions list would be fruitless, that Turkey is too important a strategic ally to the United Kingdom for these applications to be successful. But we don't feel that way, and we have grounds for optimism. Firstly, the United Kingdom government will have noticed the deterioration of human rights in Turkey in recent years and will recognise the value of taking measures to prevent further decline, and they should be sympathetic to our application and also consider that there is some credibility to our missions. Secondly, our application is full square in line with United Kingdom guidance issued alongside the sanctions legislation, which stresses the imperative of using the sanctions regime to deter repressions of human rights defenders. That's a clear focus in the government guidance. We also think that there is strong evidence and compelling grounds to act in relation to particular actors in Turkey. And also we're encouraged that the United Kingdom government has already placed citizens of countries such as Saudi Arabia on a sanctions list, indicating that our government is not deterred from putting persons on sanctions lists, even when they are countries that are considered to be allies, which is an encouraging and intelligent approach. Lastly, before giving way to Michael, we consider that our campaign is really in many ways a test case. If the United Kingdom government does impose sanctions on individuals from countries that are considered to be key strategic allies, then this would be a powerful statement that human rights abusers can be deterred anywhere in the world. If governments can see past the flag of the country where the human rights abusers are based and are able to objectively consider individual cases, then you are well on the road towards building a new system of global law, and one that could become extremely important in the years to come. So this is the aim of our application. Lastly, a big thank you to all of the panel, and particularly those who have been a real inspiration to our campaign and to many others. Also, greetings to our brother lawyers like Kerem in Turkey. So kolay gelsin and geçmiş olsun to them, and we hope that the situation will get better than it is currently. Thank you very much.